And you are live.
Thank you. Good evening, everyone. Welcome to the City of Annapolis Board of Appeals regular virtual meeting for November 7th, 2023. This meeting is being broadcast on the City of Annapolis YouTube channel. My name is Bob Gallagher. I chair the board. This virtual format allows the public to observe the meeting through video link, to submit comments through the City of Annapolis website, links to the YouTube channel, the comment form on the city's website, and database for case information of our cases you may hear about tonight should be included in the agenda for tonight's meeting. The people that you see on the screen are the members of the board. When a case is called, representatives of the parties to the case will also appear. You may also see on the screen our recording secretary, Kim Consoli. Our broadcast technician tonight is Madeline. Also participating may be representatives of the city attorney's office, board counsel, Jackie Rouse, who is liaison from the Department of Planning and Zoning to the board, and one or more members of the planning staff. So we'll begin tonight asking Ms. Consoli to call the roll.
Mr. Gallagher.
Yes.
Dr. Chen.
Present.
Mr. Walsh.
Yes.
Mr. Zazali.
Here.
And Mr. Hector.
Here.
Mr. Chairman, we have 5 members present.
Wonderful. Good to see all of you. Thank you for coming. Have the members of the board had a chance to review the agenda? And if there are no corrections or additions, is there a motion to approve it?
So moved.
Second.
All in favor?
Aye.
Aye.
That's unanimous. We also have minutes that we need to have a look at. Ms. Consoli has provided us with the draft of the minutes for the meeting of October 18th, 2023. Do we have any corrections or additions to the minutes? Will there be a motion to approve minutes?
I move the
Motion
minutes.
to approve.
Second.
All right. I think I heard a second. So
Yes.
all in favor?
Aye.
Aye.
Sustain.
Well, we're batting 1,000 so far.
Oh.
Okay, Madeline, if you'd like to bring in the folks for who are interested in the Eastport loss of Eastport Landing case, we'll move right into that.
Ed Hartman here, but my video will not allow to come on because my host has prevented it.
Well, Madeline will have to take a look at that.
There we go. That just got a new window. Okay, good.
We get. Oh, I see. We have a 2-for-1.
That's right.
Good evening, Mr. Rogers.
Evening.
I think we're missing Alan.
Oh, he's here.
He's here.
Oh, everyone's here? All right. All right. So we'll turn now to appeal application by Mr. Hartman on behalf of Mr. Rogers of the planning director's determination that the appeal application filed on behalf of Mr. Rogers of the issuance of the Department of Planning and Zoning's most recent approval of the certificate of adequate public facilities was not timely filed. We're referring to the project at 915 Chesapeake Street, known as the Lofts at Eastport Landing. So tonight we continue with preliminary matters, trying to get this case ready for final argument and decision, which I hope will happen at the next meeting. My original plan for tonight was to briefly review the legal framework for the issues we're going to be addressing, see if we're all on board there. Finally, nail down the content of the record on appeal and set the schedule for the final argument and decision on the merits. But before we get to that, you'll recall at the last meeting, the board asked the parties to confer and try to come up with agreement on the content of the record, stipulation of relevant facts. I think the content of the record was due on the 25th and the stipulation of facts on the 1st. We received from the city and the applicants a joint statement of facts. And we received from Mr. Hartman a response to the city's joint statement of facts with a statement of his own facts. So that response raised another set of issues that I think we need to deal with before we get on to the points that I had mentioned. Let's see. So the joint response expressed some considerable concern. Mr. Hartman's response to the joint response expressed considerable concern about whether that response by the city and the applicants misrepresented the participation of Mr. Hartman and his client in the response. Now, I assume you hadn't had a chance to read the joint statement by the city and the applicant before you said that. Now you've had a chance to review it. Do you still have any concerns that the city or the applicant has made unauthorized representations on your behalf?
Well, the point of my response was several. One is that I believe that it is a misrepresentation to file a joint statement of any kind when the primary parties to an action do not agree. A joint response in this matter would be a response between basically by Mr. Hyatt on behalf of his client and me on behalf of my client, Mr. Rogers.
I was
just making. I'm sorry.
You misunderstand who the parties to the case are.
No, I disagree who the parties are.
We
It's
expect,
not a misunderstanding.
Mr. Hartman, it is a misunderstanding. We expect counsel who appear before the board to familiarize themselves with the rules of the board and with the history of the case in which they're appearing. The rules of the board make it absolutely clear that the city is a party to every appeal. The city is a party to every appeal. And that joint statement by the city and the applicant says this is a joint statement by the city and the applicant. In fact, there's a footnote that said, pursuant to the board's request, they invited you to enter into discussions with them and you declined. So,
Well, yeah,
and beyond that, the issue of whether the city's a party was litigated by Mr. Rogers 2 years ago and ruled against him. So that question is settled.
Again, I don't believe that issue is really determinative one way or the other, but it is my position in this case. I'm not familiar with Mr. Rogers' particular appeal or where that went, but there is no particular precedent. But my point was strictly as to the titling of it as a joint response has always, through my 40 years of litigation, implied the consent of all parties to it. And I'm not really interested in making the argument here. I don't think that's determinative today. I'm just explaining the basis of my response. I'm preserving, if necessary, for future appeals, the issue of whether or not the city office of law and the director of planning and zoning should be participating in an appeal of this decision of the Department of Planning and Zoning. So that's all.
And Mr. Hartman, in addition to your response, you sent an email to Ms. Rouse directing her not to forward the joint response to the board. What is your authority for directing Ms. Rouse to
I was actually
interfere
referring-
with Ms. Rouse's
I was referring
assisting
to
board its operations.
I was referring to a different document, and I think there may have been a misunderstanding. You had directed us last time to attempt to reach a stipulated set of facts, and we were unable to do so. And so I wanted to make sure that that
What do you
particular
mean you
document,
weren't able to do so? Did you confer with Mr. Hartman and counsel for the city?
I conferred with Mr. Hyatt. He presented me a proposed stipulated set of facts, and we did not agree. And so therefore, I wanted to make sure that it didn't get unintentionally submitted because it was not, in fact, a stipulated set of facts. And I don't think it did. So
So
I
what
think that's
circumstances justify you directing Ms. Rouse not to send something to the board? You're interfering with the operation of the board, and we're not going to.
not at all. I'm a party to this proceeding, and I am certainly authorized to communicate with the clerk of the board who's sending documents. I wanted to simply make sure.
Would you
that it was
direct the
clear.
clerk of the court not to send something to the court?
Certainly I would. I wouldn't direct her, but I would make my opinion known, that make it clear that I did not consent to a particular document. Therefore, it is inappropriate, so that there's no misunderstanding. There was no stipulated set of facts. We were unable to agree. And so therefore, nothing should be submitted just in case it was in her possession.
I don't want to waste a lot more time on this. One last point. You make the unsupported allegation in your response that the acting director, Mr. Smith, is acting under a conflict of interest. You offer nothing in support of that allegation. So I'm going to give you until Friday to provide written support for your allegation that Mr. Smith has acted improperly, or we're going to deem that point withdrawn. Mr. Smith has been before us many times, and in the board's experience, he's always acted with the utmost integrity. And to impugn his reputation without any basis.
I'm not impugning his reputation, and I don't understand why you're taking this tact with me at this point. I made my point clear. I do not believe, as a legal matter, that it is appropriate for the determiner of a decision whose decision is being appealed to participate in the appeal of that. I have never seen a judge of a circuit court participate in the appeal of his decision to the appellate court. It just doesn't happen. And
Mr. Chairman,
but I realize it does happen here, and I don't know, there is no precedent on this issue, and I'm preserving my right, and I'm explaining the basis of my objection. It is not a personal attack at all against Mr. Smith. Of course not. It is obviously established practice, and but however, it's one with which I disagree, and I have to raise an objection to preserve that if it were to go forward to a higher court. If I don't, I will be deemed to have waived it. This is my job. This is what I did.
Mr. Hyatt?
Yeah, I just want to make one statement. You've seen the banter back and forth, and you've made your comment on it. And Mr. Hartman and I do not agree on the procedure here, but I do want to point out on the record that your rules, specifically Rule 5.2, state that parties to an appeal include the Department of Planning and Zoning, the applicant, and the appellant. There is no question that the Department of Planning and Zoning is a party here. Just no question.
Well, apparently Mr. Hartman still has a question. Let him take it up with the reviewing court.
I'm not at all interested in arguing that point here, Mr. Gallagher. I'm simply raising that point for the record. I believe there's a different interpretation of that under 5.2, but I don't believe that it has anything to do with why we're here tonight. I'm simply preserving that as a possible question on appeal if this were to go any farther than.
But before you preserve it, you should substantiate a conflict of interest claim before us or within time. If not, it's withdrawn and should not even be part of the record. Period.
Again,
you wouldn't do that to a judge in a court. You don't do it in an administrative proceeding either.
Of course I would. If I believe that a particular judge was acting in a way that was inappropriate to the proceeding, I would of course raise it.
But you would also make that claim with some substance, and I'd have to see that.
The substance is just what I have said, that it is, I believe,
based on an inappropriate, in my mind, you're not reading the regulations of our board correctly.
Well,
He's
I
a part of
understand that, and you know, we can disagree as to the interpretation of a particular rule and whether it's authorized to be made under the grant of authority from the Maryland Code, and go down that road without taking it personally. It is a
Oh,
legal
no, why would
position.
you
I
take
think.
conflict of interest personally? No, I can't imagine that.
Well, it's not. It's
Without
not a slight
substantiation.
against. It is simply. It is a. I believe the procedure that the city is following is improper, and I'm simply noting that for the record. But it really has nothing to do with the motion before the board tonight.
Right.
It's certainly not a slight against Mr. Smith.
Oh, no.
It's not. It's a procedure I disagree with.
All right, if you have any grounds, get them to us. by
I've stated
Friday.
the grounds repeatedly tonight.
All right, so
Yeah,
then we're not going to, unless the board thinks otherwise, we don't see any reason to address that issue. So let's get to the legal framework of the issues we are going to address. So I think we all agree that under Title 22, 3210, appeals of a certificate have to be made in compliance with Title 21. Is there any disagreement about that?
You're asking me? No.
Okay.
I agree that
Not
appeals have to
in,
follow.
not in full compliance. It has to comply with 21.30, those procedures.
30.20, yeah, right. And so that was the second point, that under 2130.20, notice must be given within 30 days and specify the grounds. Is there any quarrel with that?
Is there any quarrel that the rule says that? No. Perhaps this might be more efficient if you simply allow me to argue my motion, and because rather than
we're going to argue the motion at the next meeting. We're going to have a final argument on the merits at the next meeting. So I think there are two areas where there is disagreement, and let's see if we agree on the disagreement. Does the requirement of 2110.20E that the director give notice of the certificate to Mr. Rogers within 5 days of the decision apply in this appeal? So I take it that, well, you tell us, Mr. Hartman.
I believe it does. I believe the rule is very clear that it does.
And Mr. Hyatt?
It does not.
It does.
Clearly does not.
Okay.
2110.20 deals with public hearings before the concerning zoning matters, and we are dealing with Title 22, adequacy of public facilities, and the only tie-in to Title 21 is the fact that the Board of Appeals hears the appeal. They conduct, your board conducts the appeal, and the procedure has to be followed under 21.30. That is it. The other sections of chapter of Title 21 have no applicability whatsoever to an APF determination.
Now, I understood that's what you said in your brief. I thank you all
Yep.
for your
Okay.
briefs. And then the last point, is there any provision of Maryland law or the Annapolis Code that directly or implicitly authorizes the director to extend the deadline for filing an appeal or to waive the specification of grounds requirement? So, Mr. Hartman, I expect you and Mr. Hyatt have different views on that too. Is that correct?
Probably. I won't speak for Mr. Hyatt, but I suspect that's true. Yes.
And so at our final argument at the next meeting, I expect you to provide whatever authority you have to support that.
Okay.
So the facts, they don't seem, after reading all of your submissions, they don't seem as complicated to me as I thought they were. And everyone has sort of offered their own organization of the documents, and that, I think, has left me confused. So I think there are only 10 or 12 at the most documents that will constitute the record. So let's see if we can just agree on them, and we'll get Ms. Consoli to mark them accordingly. So let's start with the certificate and the mitigation plan. Is there any objection that they're part of the record?
No objection.
Then these are roughly in chronological order. If they're not, you'll let me know. There was we had a page, it was an e-tracket entry that showed that certificate and mitigation plan were logged on e-tracket on July 7th. Is there any objection to that?
Doesn't show the date.
I don't believe that document shows the date, but I also have similar, as long as the counter documents that I have are presented as part of the record, yes.
Okay, so you'll make sure to let me know what those are when we get to that point. Then we have an email from Mr. Rogers to Mr. Smith on July 10th, attaching the certificate and the plan.
I think it's from Mr. Smith to Mr. Rogers.
Sorry, you're right.
Yeah.
Email to Rogers from Smith, yeah. We okay with that?
I am. I haven't heard Mr. Hyatt comment on any of these, so.
Yeah, you asked if there's any objection. I haven't objected yet.
Good.
Okay.
And then we have an email from Mr. Rogers to Mr. Smith. Is the date the 25th? Complaining about not getting enough information, asking for 30 days, and implying an appeal.
What was the date of that? 25th?
Was it the 25th or 28th? You are more familiar, some of you are more familiar than I am.
I'm looking at an email from Mr. Rogers to Mr. Smith dated July 25th.
25th, yeah, that's what I said, okay.
Yeah.
Any problem with that, counsel?
No.
Nope.
And then we have an email from Mr. Rogers to Mr. Smith on the 28th, advising that Ms. Halleck has withdrawn and requesting a 30-day extension.
I'm not sure which, I assume that's the one that also has the language that I have quoted in my documents. I just want to make sure we're talking about the same email that says appeals hereby noted and refers to a document that is titled Notice of Appeal. Is that the same
you're
email?
referring to, Mr. Hyatt?
There's,
Yeah.
I'm sorry, there's an email from Stephen Rogers to Mr. Smith dated July 25th. And then there was a
Email from Rogers.
Smith email response on July 25th. Did you mention that one?
I didn't. Is that something you want in there?
Yeah, I think so.
All right.
No objection to that.
So that's an email from Smith to Rogers.
Rebuttal to the 25th email.
And then the July 20, you mentioned July 28th, there's an email from Mr. Rogers to a group, including myself, that mentions that an appeal is noted, and then there's an attachment to that. So that can be part of the record, yes.
Yeah, no, that's I think that's the one I just described.
Yes.
That's an
That's what I was asking you. And Mr. Hyatt confirmed that is the same one. I have no objection to that.
And then there is another document from Mr. Rogers on the 28th in the form of a pleading that I think formally asks for the extension. And it also refers to intention to appeal. So are we good with that one?
Yes.
Yes.
And then we have the appeal form filed by Mr. Rogers on August 8th. And the question there was, he refers to an attachment that he calls appeal matters. What is the state of the record as to whether that appeal matters document was attached to the form? Do we know?
Whether there was a document attached to your,
There's a narrative.
It was a motion. It was
Two-page
a
narrative.
motion to extend, a motion
Yeah.
for extension of time is
Yeah,
what
that was the 28th.
No, that was the August 8th, document also.
Okay. Oh,
but there was an attachment to, yeah, is the simple answer. And it's a, well, that's a different one. It,
Yeah, the July 28th has the Word document attachment.
right, I don't even see this, but it looks like that.
Yeah.
It's a narrative.
Mhm.
all right. So that was, yeah, that's August 8th, right?
Correct. And it says 8/8/23 in the upper right-hand corner in handwriting, the attachment does. And signed on the second
All right.
page by Mr. Rogers.
And then, Mr. Hyatt, what was the next one you mentioned?
Well, attached to that appeal form is a description from Mr. Rogers describing the appeal matters, as he calls them.
Yeah, right.
We're talking about the same document.
Yep, and then there's also a motion for extension of time. I don't know if that was an attachment or that's a separate document.
I think it's separate. That one's dated August 11th.
Okay, then that other document I just referred to is the only attachment to the appeal form.
So on August 11th, what's it called again?
The August 11th document is called Motion for Extension of Time to File Appeal.
Okay,
So,
yeah, I've got that.
okay.
And then we have an email from Mr. Smith to Mr. Rogers on August 11th. The appeal is not timely and lacks specificity.
What number document is that, Bob? What are we up to?
It depends. I have it as 9, but if we add in,
Well, that would be my 9 too, so just trying to.
I have 10.
yeah, that's because we added in an email from Mr. Smith to Mr. Rogers on September 25th
Right,
in response to the email going the other way.
right.
So
Oh, right, I see it off to the side. I do have that one, okay.
So we're good then with that,
10 documents thus far.
with
Yep.
Rogers 11, Smith to Rogers 11/23. And then the last one I had, and we'll see if you have any more to fill in. We have an email exchange I have between Mr. Rogers and Mr. Smith seeking and denying reconsideration. I don't have the date on that one in front of me. One of you on top of that. That would have,
There are a number of emails dated on the same day, August
Yeah,
11th.
they're all happening in the afternoon. It started at 11 in the morning and go on through 3 and 4 o'clock. And I
okay,
guess the last one is at 4:18. Is that right?
I think that's right.
I think there's also one at 4:58.
Do I have a 4:58?
That's an earlier date. That's the 458 one was August.
You're
8th.
right. You're right. Yep.
And that could
That's
be in the
correct.
record too, I think.
what was it, August 8th?
Yes.
August 8th, 4:58.
And what was that one, August 8th?
That was an email from Mr. Rogers to Mr. Smith, dated August 8th at 4:58 p.m. I mean, I think you could group all those
We have
emails
that?
into
Yeah,
one.
it's here. It's more opinion based Rogers to Smith stuff.
Okay,
I mean, it is what it is. If y'all
All right.
want it in there, it's fine.
so that's where I was on this. Now, did I leave anything out, either, Mr.
There's also the
Mr.
check.
Hartman, Mr. Hyatt?
There was the check that was cashed by the city of Annapolis
Um,
for the appeal fee.
Yeah, that check wasn't cashed and it came later. So I don't think that should be part of the record. The record should contain documents that Tom Smith relied upon in making his decision.
Yeah, the Friday at 11:21, Friday the 11th at 11:21 talks about a check not being taken in earnest. It was not received.
Right.
Well, we submitted the copy of the check and the receipt for it. So,
But listen, let me interrupt you.
Yeah.
The appeal hasn't been rejected because of failure to pay the fee. So I don't see what relevance that is to our decision on timeliness of the fee.
well, again, I believe that it has to do with the city's reactions to it, and there are legal issues which apply to everyone. I don't think there's any reason to exclude something from the record. You can choose to decide that it does not have any merit on it, but to exclude it procedurally, just
Mr. Hyatt, do you object?
Well, I do, because the check was dated August 15th, I believe. So Tom Smith's decision that's the subject of the appeal is August 11th. So anything that happened after August 11th,
was being received. Yeah.
in terms of, it doesn't have any relevance to Tom Smith's decision.
Well, I don't necessarily agree with Mr. Hyatt's characterization of this proceeding. So I would ask that it be included in the record, and certainly argument can be made about that particular document at the time. If you agree with Mr. Hyatt that it's irrelevant, then you can treat it as such, but I would like to have it present.
All right, you can make your proffer on that. We'll leave it out of the record.
Very well.
Okay, and was there anything else, Mr. Hartman, that we've overlooked?
I don't think so.
All right, and
I submitted 6 documents by email. I think we covered them all.
I think we have to. So may I ask for a volunteer to put these in a single compilation with serial numbers and make sure the parties and the board get a copy? So we're all working from the same page at the next meeting.
I'll do that. I'll just run it by Mr. Hyatt first to make sure I haven't missed anything.
Good. All right, that sounds good to me. So then, you've already briefed these and we've had some argument on them, but our next meeting is going to be on December 5th. But if any of you feel the need to, and that will be a sort of final oral argument. You can make whatever arguments you want then. I think probably 15 minutes each ought to be plenty. If you think you need more, we'll talk about that. But if you feel like you need to file anything in writing before that time, before December 5th, then please do so by the 28th.
By November 28th. Okay.
28th.
Mm-hmm.
So are the board members of the board happy with where we are in this? Do you need to ask any questions at this point? We're good.
Fine. I'm
No.
fine.
I'm fine.
Thanks. Okay. Well, then we'll see you all on December 5th. Have a nice Thanksgiving.
Also 7 o'clock that evening.
Yeah, it will be. So Madeline, gentlemen, thank you again for your submissions on this. It's helpful. Have a lovely Thanksgiving and we'll see you on December 5th.
Hey, thank you.
Thank you very much.
Madeline, you may excuse our parties to the case here.
Jeff, did you have a question?
Yeah, I had one brief point. The department submitted a brief on Friday, Mr. Chairman and members. I just wanted to make one clarification of a small mistake in the brief. The brief references an email that we've all talked about. It was Mr. Rogers' email to Smith on July 28th. The department's brief mistakenly references that email as having been sent on the 29th. It was just a typo throughout the 6 or 7 pages. It meant the 28th. It stated the 29th. It's the same email.
But with the date, the correct date will be apparent on document.
Thank you, Mr. Chairman. That's all.
Okay, before we-
I have a question.
Yes,
So
ma'am.
on December 5th, we are still in a continuation of,
yes,
of the hearing from tonight.
Yeah.
Correct?
yes.
Okay. Thank you.
Also for the agenda, Jackie or Kim, whoever is most interested, also on the agenda for the December meeting, we now need to revisit once more the subject of resuming in-person meetings.
Okay.
Jackie's not going to give a hoot because she'll be have her toes in the sand somewhere.
Mm-hmm.
But
Well, we'll add that to the agenda as a business item.
I had a brief conversation with the new director of the department, and he tells me that the other departments the other commissions that he works with are moving in that direction, and they're moving in a direction that I think I had suggested when we considered this earlier, and that was that our regular monthly meeting would be in person back in the city council office starting in January, but if it was necessary for us to have a special meeting on the third Wednesday, that we would be able to do that by Zoom, by virtual meeting. And I understand that our tech support folks have said that that's not going to be a problem. They'll be able to do that for us. So think about that. And I think it's gone beyond the thinking stage, even in the planning department. It's when I joined the call, Kim was talking about being asked to figure out how to get our parking validated. If that gives you a clue how these decisions get made. So anything else we need to address tonight?
Just looking forward in the December and January, I know we've got to come up with our annual report and review our terms and who's going to serve where. Just put that out there.
You know, I believe 3 of us now are serving after the expiration of our terms. And Hillary knows it. I've spoken directly to the mayor about it and the mayor's chief of staff, and the new director knows about it, and he said he was going to take it up with the mayor. Our rules permit us to continue to serve until someone else is appointed, so I guess we'll do that. But it is disappointing.
So, and we've also reminded Hillary, just within the last couple of weeks, I reminded her that we still have the vacant alternate position.
Yeah.
And as you move back into being in live meetings, I think it becomes even more important that we have that 6th person in order to make sure you have quorums.
Yeah, no, we all agree.
So, I didn't get any response to that, but I did put it forth.
Well, we'll just all work 2% harder and round out the 6%. For you math wizards.
Jackie, tell the boss that we want your replacement to be able to speak truth to power like Jackie does.
Well, I'm going to miss you all a little bit, but I am looking forward to not working. So,
Amen.
So,
amen.
Qualifying that.
So we might not see your smiling face again. On this
No, you're not
calendar.
going to see me again because I'll be gone November. I have 11 days, 11 working days left. So I'm in the countdown mode.
Motion to thank Jackie for her service to this board.
Absolutely.
Thank you so
Second.
much. I really
Second.
appreciate it.
For sure. Yeah.
So, and
This is
I
great.
was going to have a retirement party, but I decided last week that I don't want to have one. So I'm not, there is no party. I don't want a party. And I don't feel like I need to explain to anybody why I don't want a party. I'm just not having a party. So this is my vibe.
Oh,
Jackie, we can't thank you enough
Thank you,
for
Jackie.
everything.
Yeah,
you've
it's
done
been,
for
I
us.
really enjoyed working with you all. I think you're like a really great group. Everybody except, let me see, who am I going to accept from that? Oh, I won't accept anybody. All of you have been terrific. So it's really been one of the most rewarding things to work with you all.
Oh,
So
thank you, Jackie.
Thank you, Jackie,
thank
for
you.
everything.
Thank you, Jackie.
No,
Enjoy
thank you
your,
all.
Best
enjoy your
wishes for going
retirement.
forward.
Thanks.
All right. Is there a motion to adjourn?
I
Motion
move.
that we adjourn.
All in favor?
Aye.
We're out of here.
Happy Thanksgiving, everyone.
Yep,
you.
to you
Everyone
too.